Thank you, Mr. Chairman. Welcome to today's witnesses. Before turning to today's topic, I do hope this committee will hold a hearing soon on sanctioning Russia for this horrific invasion of Ukraine. To throttle Putin's ability to wage war in Europe, the U.S. must bring Russia's economy to its knees. This means direct sanctions on Russia's oil and gas sector. Ending U.S. purchases is a start, but we also need the rest of the world to stop funding Putin's war machine. That probably is going to require secondary sanctions on Russian banks. Secondary sanctions would force the world to choose between doing business with Russia or with the United States. We know what people will choose. This is a very important issue that is, in fact, entirely within the jurisdiction of this committee, so I hope we will take it up soon. Now, turning to today's topic, the hearing's about mandatory arbitration agreements. And these, of course, are contracts where financial institutions and consumers agree to use arbitration instead of litigation to resolve disputes. They're commonly used for products like checking accounts and credit cards. Arbitration is a fair and cost-effective process for resolving disputes outside of court, which generally leads to better outcomes for consumers than litigation does. But arbitration agreements in consumer financial services have come under attack in recent years. In 2017, the CFPB issued a rule that would have banned these agreements from consumer financial products. However, Congress overturned this rule under the Congressional Review Act. Since then, a number of my colleagues have introduced bills that would undo Congress's sensible decision. These misguided efforts would harm consumers, undermine the freedom of contract, and give away millions of dollars to trial lawyers. If these efforts are successful, aggrieved consumers would receive less money less quickly. Protecting consumers doesn't require the government to stop adults from entering into agreements and undermine their freedom of contract, nor does it require the government to micromanage the terms of the contracts. That's not protection, that's paternalism. It treats adults as incapable of making their own decisions without interference from the government. Consumers who don't want to sign mandatory arbitration agreements have other options. According to data collected by the CFPB itself, in 2015, 84% of credit card issuers and 92% of banks offering checking accounts do not use mandatory arbitration agreements in their contracts for those products. So any consumer in America who prefers to settle a dispute in litigation rather than arbitration has many opportunities to select a financial product that allows for that. Consumers do have a choice. Of course, in reality, most consumers don't make decisions based on whether their contract has an arbitration agreement. They don't need to. As multiple studies have shown, consumers generally do better in arbitration than they do in court. According to one recent study, consumers prevail on the merits 14% more often in arbitration than in court. CFPB data showed that the majority of consumers who go to arbitration have higher rates of securing settlements or awards compared to consumers who sue as individual claimants in federal courts. Moreover, the average recovery per consumer for class action settlements was $32, while a consumer who prevailed in arbitration was awarded an average of $5,389. What's more, arbitration is more efficient and cost-effective at resolving disputes than litigation. For example, consumers don't need to pay expensive fees to lawyers to represent them in arbitration. In fact, consumers who represented themselves won on the merits in arbitration more often than those who hired lawyers to represent them. And disputes are resolved much more quickly in arbitration than they are in court. By contrast, lawsuits can be very costly, especially class action lawsuits. That's why restricting arbitration agreements would actually likely drive up the cost of financial services, which increases prices for consumers who have already been harmed by 40-year high inflation. It would also deprive consumers of the ability to access arbitration. For instance, according to the Independent Community Bankers Association, it would not be economical for community banks to continue to subsidize arbitration for customers if they're forced to carry the high cost from increased class action lawsuits. Trial lawyers sometimes claim that class action litigation is necessary to punish or deter wrongdoing. But ultimately, the most powerful incentive for financial institutions to take good care of their customers is that if they don't, someone else will. The market for consumer financial products is extremely competitive. And when they don't, financial services providers are already subject to stringent scrutiny by regulators with the potential for incurring massive financial penalties for wrongdoing. In the end, it's not consumers who benefit from banning arbitration agreements. It's trial lawyers. As I mentioned, each consumer's average recovery was just $32 in class action settlements. By contrast, trial lawyers average more than $1 million in attorney's fees per settlement. That's not consumer protection, it's lawyer protection. And liberal advocacy groups get a windfall too. Some class action settlements require payment to a nonprofit instead of consumers, even though the nonprofit was in no way harmed and probably has never even been a customer of the financial institution. In fact, 2 of the witnesses advocating against arbitration agreements today are from groups that actively solicit these awards. Hardly disinterested advocates. Restricting arbitration would be little more than a government-sponsored bonanza for trial lawyers and certain liberal advocacy groups at the expense of consumers seeking a fast and fair resolution of their disputes. Arbitration leads to better consumer outcomes and lower costs. Nothing about arbitration agreements merits the government stepping in to restrict the freedom of contract and to micromanage consumer decisions. Thank you, Mr. Chairman.